Hi guys, welcome back to Peasant Tony. Today we are going to talk about Miranda's warning and when it should be given and how to identify situations that involve Miranda warning on the New York bar exam. Now the basic question is, what is Miranda's warning? It is a warning where the police often says in the movie when they arrest somebody, they tell you, hey, you have the right to remain silent. Anything you say may be used against you at trial. And if you want to a counsel, you have right to an attorney or legal advice. That is essentially the Miranda's warning. And the problem with the Miranda warning is that when the Miranda warning is not given when it's supposed to should have been given, whatever self-incriminating evidence or any kind of evidence that the suspect gives is inadmissible at trial. So this goes to the heart of admissibility of evidence. So for example, somebody says, hey, I committed the crime, but that person, no Miranda warning was given, then whatever he says, that evidence is not admissible at trial. Okay? Now we'll go over situations when Miranda warning should have been given, and as you can see, Miranda warning should be given when a person is in custody and is being interrogated. In one word, it's a custodial interrogation. This is key point, and it leads to two-part test. Again, the person has to be in custody, and second, there has to be an interrogation by the police. Then that person being in custody and being interrogated by the police has the right to Miranda warning, in which the police needs to tell that person, before I ask any questions, you have the right to remain silent. Anything you say may be used against you at trial, and you have the right to an attorney. Now, it's a two-part test going back. So when is a person in custody? It is a factual inquiry based on a reasonable belief that a person is not free to leave. Now, again, it is a reasonable belief that a person is not free to leave. These are the two key aspects of custody. So for example, a police walks up to you and says, hey, what is going on here? Can you leave? Yeah, you can always say, I don't know, and just walk away. Now, so those kind of situations, police does not need to give you any kind of Miranda warning when the police comes up just to ask what is going on, because the person is not in custody by the police. However, another example in custody is a police walks up to you and tells you, hey, stop, you can't go. Are you in custody? Yes, because it is reasonable to believe by the person being told by the police not to leave that they are not free to leave. So it's a factual question, and it really is dependent on the subjective belief by the person being told in conversation with the police and what the police says. So keep that in mind for the custody aspect. Another example of custody is that you're at home and the police suddenly barges into your house and hands a gun and tells you to freeze. Are you in custody? Probably, because a police coming into your room and telling you to freeze, you have a reasonable belief that you're not free to leave that area. So the custody establishes. Now, second part is the interrogation, meaning there has to be words and actions by the police for the second part to be triggered. Now this is where it gets a bit tricky, but I want you to focus on words and actions. They have to be present for the Miranda warning to be triggered. So you could be in custody, but if police is not acting on any words or actions that may lead you to confess any self-incriminating evidence, Miranda warning is not triggered. So, for example, you're in a police car and then you're driving to a police station. Does the police need to give you Miranda warning? Let's take through the test. Are you in a custody in a police car? Yes, because you're not free to leave the police car, and it's reasonable for one to believe that you're not free to leave. So the custody check. But you're in a police car and police is not saying anything. So there are no words or actions that is being done by the police that may lead you to self-incriminating evidence. So Miranda warning is not triggered. So the essence of the question ends up being, a police arrested somebody, and as they drive to the police station, the police does not say anything or asks anything, any questions to the suspect. But the suspect becomes nervous and confesses that he committed the crime. Is that evidence admissible? The answer is yes, because as there is no interrogation by the police before the suspect confessed, Miranda warning is not triggered, and that evidence is admissible. And another example is, for example, a police arrests you and place you in the police car, and as you guys driving to the police station, the police suddenly asks you a question. Did you commit the crime? Then is the Miranda warning triggered then? The answer is yes, because the fact that the police asked you a question, interrogating, which reasonably leads you to believe that you may make a self-incriminating evidence, Miranda warning is triggered. So there's one thing about custody, but second thing is the key aspect, usually often showing on the question, is that there has to be some form of interrogation through words or actions by the police for the Miranda warning to be triggered. Going back on the example, a police comes to your house after receiving a call that somebody died in your place, and then police knocks on your door and you open up, and police asks you, hey, what is going on? And you feel scared and you feel intimidated and you confess, hey, you know what, in fact I killed somebody in my house. Now, is that evidence admissible subject to Miranda warning? Yes, because in that situation Miranda warning did not need to be given, because you're not under custody and you're not under interrogation, because it's a general question. So it has to be very factual specific, and you will need to solve some questions to recognize what type of situations would be considered custody and what type of questions by the police would be considered interrogation. And second thing about the Miranda warning is that it is not triggered when the police is an undercover cop. Just remember that. The suspect who makes a self-incriminating evidence, who wants to be saved under Miranda warning, needs to be aware that whoever interrogating you is a cop. So if you're undercover cop, Miranda warning does not apply. Undercover cop, Miranda warning, they don't need to give it to you. And how do you trigger your right to counsel under the Fifth Amendment? You just need to clearly and explicitly say, I want a lawyer. And that is key point, clear and explicit. So no maybes, no maybe, no possibly, let me think about it, none of that. You need to be clear and say, when a police gives you, you have the right to remain silent, you have anything you may say may be incriminating, and you have right to counsel. And if you want to trigger your right to counsel under the Fifth Amendment, you need to say it clear. I want a lawyer. Otherwise, if you say something like, hey, you know what, I'm not sure if I want a lawyer right now, but I'll think about it, and then later on you go confess, then that confession is admissible. But when you say, I want a lawyer, and then later on you still confess, then that confession is not admissible unless you are already given a lawyer. Now, how to seek the Fifth Amendment? It's a clear, explicit words asking for counsel. Now, this is the basic form of Miranda right, and if you just understand this basic form of concept of when the Miranda warning is given and in what situations the Miranda warning needs to be given and how to explicitly ask for counsel to trigger your right under the Fifth Amendment, you should be fine with the New York Bar exam. Good luck with New York Bar exam, and come back to Peasant Tony for more law. Enjoy.